Good morning, everyone. My name is Sylvia Watson, and I'm here with Trevor Oakerson for the webinar on Interlocal Agreements. I will be helping Trevor monitor the chat box and field questions that come in. So without further ado, here's Trevor.
Hello, everyone. My name is Trevor Oakerson, and I am a legal extern at the Indiana State Library this summer. I'm here to talk to you today about interlocal agreements. I'm really excited to share this information with you, and I hope that this can help you and your organization grow in beneficial ways. I am not, however, a licensed attorney, so I am only able to give legal information and not legal advice. I'd also like to let you know that this program will be roughly 40 minutes long, depending on the questions that are asked. This means that you will receive one LEU. A certificate will be emailed to you for your convenience. If you're here and haven't registered, you'll have to do so to get the certificate. Before we get started, I just want to point out that you can ask questions at any time using the chat box. If you have a question about a specific slide, please include the slide number that can be found in the bottom left-hand corner. At the end of the presentation, I will answer as many as I can to the best of my ability. I am not a licensed attorney, however, so I won't be able to answer any complicated or situation-specific questions. I'll provide contact information for the Library Development Office and Sylvia Watson at the end of the presentation as well, so if you have specific questions now or think of questions later, you can email them. With that being said, let's go ahead and get started. Today, we are going to be talking about interlocal agreements, such as interstate compact agreements, service agreements with townships, and partnerships with schools or other interlocal agreements. I'm going to provide you with the minimum requirements required by the state of Indiana, as well as some of the tips for drafting usable agreements. Some of the information might seem a little repetitive, but that's because it's worth repeating. Also, please note that I have color-coded the presentation for your convenience. If you're waiting on a specific type of agreement, or are looking at this video after it has been posted, the slides for interstate compact agreements will be blue, the slides for service contracts will be red, and the slides for interlocal agreements will be yellow. And the drafting recommendations and common contract clauses and provisions will be gray. Again, I put slide numbers in the bottom left-hand corner so that you can make a note about the location of any important information. When I was reviewing all of this information, I was initially confused because it seems like there could be overlap between the types of agreements. I think it is important that we take a step back for a minute and talk about how we use each agreement. The Interstate Compact Agreement is the easiest to identify. Because of these rules will apply whenever you are entering into an agreement with an agency outside the state of Indiana. It may be a little more difficult to decide between the Township Agreement and the Interlocal Agreement. Township agreements should be used when the agreement is between a library and another public library or a city, town, township, or county for the provision or receipt of library services. Interlocal agreements should be used when the agreement is between public institutions and may include more than just an extension for library services. First, we will discuss interstate compact agreements. These agreements are necessary for Indiana libraries that want to work with non-Indiana libraries on providing joint or cooperative library services to the public. Such agreements are authorized to the extent that the distribution of the population makes the provision of library services on an interstate basis the most effective way to provide adequate and efficient services. The most common type of interstate compact agreements allow libraries to issue library cards to the residents of other states, but these agreements are necessary for any type of cooperative agreement between an Indiana library and a library in another state. Before we get started, would anyone like to share any interesting interstate compact agreements that they are aware of? It doesn't look like we have any, so we'll move on. The Indiana State Library does have a template for these agreements, so feel free to contact Sylvia Watson for more information. The legal requirements for interstate compact agreements apply to Indiana and any state bordering Indiana that has joined the Interstate Library Compact. In order to be part of the Interstate Library Compact, the respective state legislature has to enact laws agreeing to be a part of the Interstate Library Compact. Currently, Indiana, Ohio, Kentucky, and Illinois are all members of the Interstate Library Compact. However, Michigan has not joined, so it is not possible for an Indiana library to do an interstate compact agreement with a library in Michigan. An interstate library compact agreement between an Indiana library and a library in Ohio, Kentucky, or Illinois would be allowed. The authority to form interstate compact agreements is given to the appropriate officials and agencies of both parties, such as boards or executive directors. For Indiana public libraries, the board is the appropriate authority. Despite this, each compact agreement must also include an administrator at the Indiana State Library who will advise the process. The Indiana State Library Director is the compact administrator for Indiana and must sign off on any interstate compact agreements entered into by an Indiana library. Sylvia Watson at the Indiana State Library can help you navigate the approval process. A state can withdraw from the Interstate Library Compact by repealing its laws related to the Interstate Library Compact. In the event a state should do this, the compact will remain in place until 6 months after the state legislature gives notice of repeal. So, you might wonder what the effect this would have on entered agreements under the Library Compact laws. Those individual agreements remain in effect until the agreement is scheduled to terminate. An interstate library compact agreement must include the following, and you'll see these on your screen. First, details about the nature of the services, facilities, properties, or personnel to which the compact is applicable. Second, provisions for the allocation of costs and financial responsibilities. Third, the rights, duties, obligations, and liabilities of the parties. Fourth, all terms that are appropriate to the proper effectuation and performance of the agreement. The detail and nature of the services, facilities, properties, or personnel to which the compact is applicable needs to define the important components of the agreement, what is being exchanged, and why it is being exchanged. The provision for the allocation of costs and other financial responsibilities needs to describe the budget of the agreement, what each party is paying into the agreement, and how the finances will be managed. The provision outlining the right, duties, obligation, and liabilities of the parties needs to specifically and clearly outline who is responsible for what components of the agreement. The terms and conditions for the duration, renewal, or termination of the agreement needs to specifically list the dates the agreement will be in effect, how the agreement can be renewed upon expiration, or how the agreement can be terminated prematurely. Additionally, you must include terms that outline how any joint property will be dispersed. Think of this section as an outline of your exit strategy. Finally, the signatures required on an interstate library compact include your library board and the board of the neighboring state's library. Additionally, the compact administrator of both states involved in the agreement must sign. This is usually the state librarians of each state. And both states' attorneys general must sign the agreement. The agreement is not limited to these terms. These are only what are required by law. We will discuss other important clauses and provisions that you might wish to include at the end of the presentation. I know that we have gone over a lot, so I'm going to review the most important information that we've touched upon about interstate compact agreements next. As we wrap up our discussion of interstate compact agreements, I think that the most important thing you need to do if you would like to enter into an interstate compact agreement is to contact Sylvia Watson at the State Library. She can provide you with a template and help you walk through the process, including getting the necessary signatures and approvals at the state level. Remember, you need the signatures of the boards of both libraries, the compact administrators of both libraries, and the attorney generals of both states. Next, we will discuss the laws that allow Indiana libraries to contract to provide library services to another Indiana public library or other Indiana municipal units, such as unserved townships. The most common type of agreement under this section of the code are the Township Agreements, where a township pays a library to provide services to the township's unserved residents. These are a little less complicated than the interstate compact agreements, so we only need to look at two sections of the Indiana Code. Before we move on, does anyone have any interesting contracts for library services that they would like to share? Well, we'll go ahead and move on. These agreements are much more straightforward than the requirements for the interstate compact agreement. The agreement itself only requires the description of the manner and extent of the library service and the amount of compensation for the extension of that service. Despite this, you will likely want to include additional details in your agreements, and we will go over a few common contract clauses in a few minutes. While the law doesn't specify the dollar amount to set in the case of providing library cards to residents of contracting townships, the state library recommends that the township should pay the full non-resident rate for the cards so that the library's district's taxpayers are not subsidizing library cards for the township residents. The compensation for the agreed upon amount identified in the contract must be acquired by one of two ways. Most municipal corporations must levy a specific tax to pay for the contract expenses. Municipal corporations located in Miami County, however, have the additional option of using existing tax money from other sources. The library is required to spend all money received for the contract on providing the services outlined in the contract. Finally, we'll go over the general interlocal agreement rules. These are not library specific, but can be used to benefit libraries in important ways. For example, we have seen these agreements between libraries and local schools to split staffing time and costs. Other interlocal agreements might include partnerships with municipalities or other public cultural resources. These rules are a little more comprehensive than the township agreements, but still pretty straightforward. Before we move on, does anyone have any interesting interlocal agreements that they would like to share? Well, it looks like we don't have any, so we'll move on. These laws apply to any public institutions in the state of Indiana and the public institutions of other states or the federal government to the extent that they are allowed to enter such agreements.
Vicki says we have just formed an agreement with our local schools to provide staff.
And it does look like Vicki has said that they have an agreement with a school to provide local staff. So that's a great example of how these partnerships can really help libraries fulfill their mission and help benefit the literacy rates of the communities around them. Before drafting these agreements, it is important to note that the powers can be allocated to either party or to both parties acting jointly. This means that these agreements need to be specific about who is responsible for which provisions of the agreement. For example, a partnership with a local school corporation might allocate funding for the acquisition of academic resources, so the agreement would have the option of assigning responsibility for those purchases in one of three ways. That responsibility can be designated to the library, to the school, or to a joint committee or designee acting on behalf of both. Every interlocal agreement under this chapter must include the duration of the agreement, the purpose of the agreement, the manner in which it will be managed and budgeted, the ways in which it may be terminated or modified, a description of the administration of the agreement, and the method of acquiring, holding, and disposing of any property of the agreement. The agreements may include any other important provisions appropriate to the situation, and we will discuss what types of provisions may be included shortly. The duration of the agreement needs to outline the time frame of the agreement and should also include any key dates such as the start dates, the end dates, and any other significant dates that the agreement will require. The purpose of the agreement needs to outline the benefits provided to each party of the agreement as well as the goals of the agreement. Parties entering into an interlocal agreement may allocate resources such as money, personnel, services, and facilities to carry out the agreement. All of these resources should be fully described in the agreement. The manner of managing and budgeting the agreement needs to detail the financial responsibilities of the parties to carry out the agreement and the financial plans underlying the agreement. This section should include any payment information, including who needs to pay whom, how much needs to be paid, when the payments need to be received, and how the payments can be made. The method of terminating an agreement needs to outline the process of how the agreement can be ended early, and if so ended, how any property will be divided. You must include the method of termination, but depending on an agreement, this may or may not be a good place to include the means of amending or changing the agreement. The description of the administration of the agreement needs to outline whether a new organization will be created and delegated powers by the parties to the agreement, or if the agreement will be managed through a joint board. This decision is really important, and the appropriate choice depends a lot on the nature of the agreement. It is also important to know that any legal entity or joint board established for the administration of the agreement only has the powers delegated to it in the agreement. So now that we've gone over what is required, we'll go over some more general rules. All of these interlocal agreements need the approval of the Attorney General unless it meets three qualifications. First, the agreement must only involve Indiana public institutions. Second, the agreement must be approved by the fiscal body of each party. Third, the agreement must delegate a treasurer to disperse and account for any monies within the joint undertaking. Again, if the agreement does not meet these three qualifications, then the approval of the Attorney General is needed. This rule is meant to make sure that the money and resources are being used appropriately. If the agreement includes the provision of services or facilities that a state officer or state agency has the power to control, that officer or agency must provide approval. This means that those ordinarily responsible for a given service or facility must be made aware of and approve any agreements that change their responsibility. There is an important caveat to this particular rule for libraries. In the case of reciprocal borrowing agreements between public libraries, this approval is assumed. The agreement must only allow access to collections to holders of the library cards from another library. Despite not needing approval for reciprocal borrowing agreements between libraries, a copy of the reciprocal borrowing agreement must still be provided to the state library for record-keeping purposes. I think that this particular caveat for libraries is actually a little redundant because there are specific provisions already in place for libraries that want to extend their services to card holders from other libraries, and we discussed those agreements in the extension of services contract agreement section. Finally, before the interlocal agreement takes effect, The agreement must be recorded with the county recorder in the county in which the library is located. The agreement must then be filed with the State Board of Accounts for audit purposes within 60 days of going into effect. Before we move on, I would like to discuss a couple of nuances that may or may not be important depending on the situation underlying the agreement. First, the rules relating to interlocal agreements for purchase, sale, or exchange of services, supplies, or equipment. Second, the rules relating to the transfer, combination, or sharing of powers, duties, or resources. Indiana Code 361712 applies to purchases, sales, or exchanges of services, supplies, or equipment. This subsection modifies the typical procedure whenever the contract is between public entities. First, contracts of this nature between Indiana governmental entities are exempt from the normal public posting requirements. Second, whenever the contract permits one Indiana governmental entity to make purchasing decisions for the other, compliance with the governing statutes by one party transfers to the other party. Third, when a governmental entity is making a purchase from another governmental entity, compliance with state purchasing law on the part of the purchaser transfers. Fourth, two or more governmental entities may procure together or with a nonprofit entity as long as it follows public purchasing laws. I would encourage anyone forming these types of agreements to also reference the applicable laws relating to the posting of public notices, to the public bidding laws, and to purchasing laws before entering into any agreements. Next, IC 361716 governs the transfer, combination, or sharing of powers, duties, functions, or resources, particularly in the area of budgets, rates, and levies. This applies in cases when an agreement would result in savings or a reduction in foreseeable expenses. In these cases, the agreement must specify the amount, if any, of the decrease. The financial body of the benefiting subdivision must then make those decreases known to the Department of Local Government Finance for the purposes of eliminating double taxation by different political subdivisions, or to eliminate any excess property taxes resulting from the savings. Again, these provisions may or may not be relevant depending on your situation, but you do need to comply if they are applicable. Now that we've gone through the basic legal requirements, I'd like to offer a few drafting recommendations. First and foremost, always review the applicable law before drafting because it may have been modified or updated. Additionally, there is rarely any need to fast-track an interlocal agreement, so always take your time to think the agreement through, to be clear, concise, and consistent, to pay attention to grammar, punctuation, and formatting. Take the time to define all of the important terms and identify all of the important parties of the agreement. Finally, the State Library can provide examples and guidance if needed. You should always, however, consult your local legal counsel because it is better to ask and find out than guess and be wrong. In addition to what is required by law and what is necessary to make sure each party understands their respective responsibilities under the contract, you might consider including some of the general contract provisions. Some of these may or may not be appropriate depending on your agreement. You may want to include an assignment clause to determine whether rights, obligations, and duties under a contract may be transferred in whole or in part to another, and under what conditions. This helps everyone keep track of who is responsible for what under the agreement and how that responsibility is allocated. You may want to include an approval and filing clause that outlines the approval process for the agreement and where the agreement shall be recorded and who is responsible for recording and filing. This helps the parties understand when an agreement begins and where the record of the agreement is kept. It also makes sure that the agreement is filed because it outlines who is responsible for filing the agreement. You may want to include a conflict of interest clause, stipulating that neither the parties nor their agencies may have any conflict of interest that will affect the performance of the agreement, and that should any conflicts of interest arise, those will be disclosed immediately. This ensures that the agreement is being drafted and will be conducted in good faith. You may want to include a force majeure clause that allows the parties to terminate the agreement should an outside force, such as a natural disaster or a change in the law, impact their ability to perform their obligations. This protects the parties from the agreement should external circumstances prevent fulfillment from being possible. You may want to include a limitation of liability clause that limits the responsibility of the parties for the behavior of the other and limits the responsibility of either party for any injury to the extent legally possible. This can protect the parties from each other and allows responsibility to be assigned to the appropriate party if anything goes wrong. You may want to include a merger and modification clause that states that the document is intended to be the final expression of the agreement and outlines the process that the parties must go through to make any additional changes to the agreement. This prevents the negotiations leading up to the agreement from being introduced into the agreement and makes all parties aware of what their responsibilities are. You may want to include a notice to parties provision that outlines where and how any important notice regarding the agreement can be sent. This makes it clear how the parties may officially communicate and ensures that the appropriate individuals receive the notice. You may want to include an ownership clause for any documents or materials that an agreement may produce to make it clear who has control over any work product. Remember, some types of agreements require a plan for the distribution of materials acquired under an agreement between the parties. You may want to include a renewal clause that explains how the contract can be renewed after its expiration. This helps the parties understand when an agreement ends or continues and where the agreement is kept. You might want to include a severability clause that preserves the agreement even if the specific provision is ruled against in subsequent court proceedings. You might want to include a payment clause that outlines how much, when, and where payments for the agreement may be made. This makes the responsibility of each party much clearer, prevents misunderstandings, and allows for better documentation. You might want to include a waiver of rights clause that protects the parties from waiving their rights under the agreement by failing to enforce a particular right. This is important because it preserves the document as the final statement of the agreed upon rights and protects parties from waiving rights intentionally or unintentionally. Take a moment to notice how these clauses might change, clarify, and otherwise impact the provisions that are required by law. It is important to note that should the agreement be disputed, the document itself will be the starting point for any legal proceedings. This means that it is very important to consider each provision in the context of the larger document. So, before we take questions and begin to wrap up, I thought it might be helpful to look at an example and walk through a contract piece by piece. I've done my best to remove identifiers, so anytime you see a generic identifier such as high school, it is a placeholder for a more specific proper noun. This contract is between a public library and a local school system. They are partnering to bring library services to the local high school and are drafting the contract under Indiana Code 3617. There are some things I really like about this contract, but there are also some things that I really do not like. Take a moment to look at the heading and introduction of the contract. The title of the contract is generally at the top of the agreement on the first page and should outline clearly and concisely the nature of the agreement. I like the way that they drafted this title because it tells you what the agreement is and who the parties are. These do not need to be elaborate, and I will note again that I have used generic placeholders rather than the proper nouns that were originally in the document. Next, look at the introduction. The introductory clause should usually include the type of the agreement, the date of the agreement, and the parties to the agreement. This particular agreement does not include that date, but that's okay. Also, if you are drafting an agreement under one of the statutes we talked about today, you should reference the statute. This group did that, as well as outlining the purpose of the agreement. I would like to take a moment and talk about the style that these groups used. You don't have to try to use legalese to make a good, usable document. The focus should really be on being as clear and concise as possible. Additionally, they have tabulated their agreement and broken it down into several proclamations. This is not really necessary, and a simple, straightforward introductory paragraph. After the title and introduction, the contract then outlines the duration and purpose of the agreement. Remember, if you're drafting a general interlocal agreement, both the duration and purpose are required by law. These are pretty straightforward examples, and both are clear and concise. I also like that, so far, the agreement is following the requirements of the statute like a checklist. This makes everything clear. Now that they've got the duration and purpose, they still need to include 4 other provisions by law. First, the manner of financing, staffing, and supplying the undertaking. Second, the methods to partially or completely terminating the agreement. Third, how the agreement will be administered. And finally, the manner of acquiring, holding, and disposing of joint property. The next section of the agreement that they chose to include is the administration section outlining the Joint Advisory Board. This takes us out of the order of the code section, but that's okay. The agreement is still clear and concise. In this case, they chose to put together a Joint Advisory Board. They outline the purpose of the board, the composition of the board, the duties of the board, and the limits of the board's authority. They seem to have done a really good job of thinking this through. I would also like to note that outlining the powers of the joint board and the limits of the board are very important. These powers need to be explicitly outlined because the statute says that the only powers that the joint board can exercise must be delegated to the joint board. Remember, interlocal agreements must include the manner of financing, staffing, and supplying a joint undertaking. They must also include the manner of acquiring, holding, and disposing of property. Here, the parties seem to have combined these 2 sections. This is okay, but I think it would be clearer and easier to follow the order that is outlined in the statute. Despite this, they did a really good job of going through their specific situation with a fine-tooth comb. In Section A, they outline the initial equipment and real property involved. In Section B, they detailed who is going to manage the equipment, who is going to acquire additional equipment, and who is going to own that equipment. In Section C, they outline how the library will be operated, including the hours it will be open and what services will be included. In Section D, they detail how the expenses will be allocated and who will provide the funds. In Section E, they talk about the staff that each party will provide to the library. In Section F, they provide for the expansion and renovation of this facility if agreed upon by both parties. This is interesting because it shows one of the ways that a power can be delegated but still limited. Finally, in Section G, they outline how gifts to the library will be handled. Again, you can really tell they put a lot of thought into this, and they did a really good job of keeping the agreement organized and clear. I know I already mentioned it, but they also provided a great example of how you might delegate a power in a limited capacity by providing for that power, but still requiring the approval of both parties. This gives the joint board the option of exercising that power if they need to, but it still preserves the powers of the parties involved. The section discussing the termination and disposition of the property is the last section that we need under Indiana law. They have clearly outlined how a termination may take place and what the process after termination will look like. One thing that I noticed in this section is that they discuss donations to the high school library, but this is the only reference to the high school library as its own entity. I think that the context makes everything pretty clear, but that could be a little bit confusing if you're not careful, especially if they reference the high school library somewhere else with a slightly different context. This is also why I advised against legalese, jargon, and terms of art. If legal jargon or terms of art are used in a slightly different way from their larger context, it can be confusing and unclear. Most of the time, this is okay, but if the document comes into question, it might be a point of contention. Remember, if a judge were to review the contract, then they would give each word and phrase meaning, and the meaning they would give each word and phrase would be impacted by all the other words and phrases of the contract. In law, we refer to this as the four corners doctrine, because the judge will start determining meaning and responsibilities based on the content within the four corners of the document. My point here is that you have to be very careful and intentional about the way you approach drafting a document. Now that they've met all the legal requirements, they decided to include additional provisions such as those we just discussed. They provided a separate provision for notice, making it very clear how communication regarding the contract should be sent and received. I really like the way they did this because it makes it so clear and it outlines every little detail of it. They decided it was necessary to outline the ways in which the contract impacts their existing responsibilities, to include a non-discrimination clause because there is a staffing agreement in the contract, and to include a severability clause to limit the impact of any particular clause being ruled against. They stipulated that any power outlined in the agreement can only be delegated with consent of both parties in the assignment clause. Remember, these all impact the way the document is read and understood. I really encourage everyone to think carefully about what the full document means. Moving on, they also include a second provision about the ownership of materials. I think it is interesting that they chose to include this here because it seems slightly redundant because this should have been clear based on the clauses that are required by law. I would recommend trying not to be repetitive or redundant because sometimes it could be contradictory and confusion. In this situation, I think that this mirrors the other language and wouldn't necessarily cause a problem, but this would be an easy way to slip up. They also included a waiver of rights clause, a force majeure clause, an approval and defiling clause, and a limitation of liability clause. One clause that they include warrants a little more explanation. They included a supplemental documents clause that allows them to draft new documents that help execute this agreement. I would be cautious about including this clause in these agreements because there is also an additional merger and modification clause that allows them to change the agreement. Moving forward, the parties will want to be absolutely clear about what is a modification of the agreement and what is a supplemental agreement made in support of the joint undertaking. Finally, they noted that the rest of the page is intentionally left blank. I think that this is helpful, even though I think that it would more often than not be unnecessary. The remaining pages in the document are merely the signature pages, so before we move on, I'd just like to encourage everyone to again take a moment to think about how all of these clauses might change the agreement. I would also like to remind everyone that the State Library has examples and templates of agreements that they are able to share with you. I know it's been a very long presentation with a lot of information. We went over interstate compact agreements. We went over the contract for services agreements and the interlocal agreements before finishing with drafting recommendations, common contract provisions and clauses, and an example agreement. So before we wrap it all up, I'd like to take a moment and ask if there are any questions.
Michigan bill is now in the House. Any idea of a timeline should this pass? Okay, so Eric is asking about a Michigan bill that's in the House. I'm assuming he's talking about a bill for them to join the Interstate Library Compact. And I was not aware that that had been introduced in the House. I was aware it was being considered, so I don't actually have any updated information on a timeline for when that would pass. But we'll take a look at that and keep an eye out for that one. And then Michelle asked, are townships we're in contract with supposed to do a tax levy to pay?
Michelle asked if there are townships that are contracted with to provide services and if they are supposed to pay a tax levy. And the answer to that question is yes, they are, unless they are in Miami County, in which they can use existing taxes. It looks like Michelle asked if they are permitted to enter into a contract with townships across county lines. I think that based on the reading of the statute, it seems like you can, because it allows you to contract directly with a township. So I don't think that the county lines are particularly significant, but I would be careful about noting where you're filing that joint agreement. So it looks like while Michelle is talking, or Michelle is typing, but this is the time to ask any other questions. Again, if you have any others that you think of later, or you're viewing this after we've gone over everything, I will be providing the information for the State Library Development Office and can provide the email to you on the next slide.
She says, can you go over the filing rules again?
Michelle, you asked about the filing rules again. Do you know which type of agreement you would like to look at?
Contract for library services.
Okay. Hold on one second and I will pull up that slide again. Oh, whoops. If I recall correctly, these are required to be filed in the county of the library. So, for example, if you're contracting with a township across county lines, you have to file that in the library's county. Okay, it doesn't look like we've got many other questions, so we'll go ahead and wrap it up if you guys are ready. Thank you guys so much for your time, and I really hope that the presentation has helped. For more information or guidance, you can contact the Library Development Office or Sylvia Watson, both at the Indiana State Library. Again, thank you so much for your time, and remember the State Library does have examples of agreements that you can be reviewing and to use to kind of guide your own agreements. Thank you so much.